Because even the justice and Supreme Court are not certainly got a time to discuss with them. So today it's a good time for you. So no need to be worried to ask questions. Feel free to ask questions. Chief Justice William will be talking about the being judge. And Judge Cooler will be talking about the how to examine the commercial cases. Dua topik ini penting sekali. Topik yang pertama, being judge. Sebagai hakim di Indonesia tidak mudah. Selain kita diawasi oleh Tuhan, tapi kita diawasi oleh dua lembaga. Satu diawasi oleh internal, badan pengawas. Yang satu diawasi oleh eksternal, komisi yudisial. Tidak mudah. Kadang-kadang putusan kita benar secara hukum, tapi banyak juga yang mempersoalkan, saya kadang-kadang kita harus menjelaskan kepada pengawas. Dalam undang-undang kita sudah dijamin hakim bebas membuat putusan selama ada pertimbangan yang bagus. Tapi ketika putusan kita kontroversial, maka pengawas juga punya alasan untuk bertanya kepada hakim. Tidak mudah. Apalagi selama ini kita mendapatkan semacam pesan dari orang tua kita bahwa hakim adalah wakil Tuhan. Sebagai wakil Tuhan, kita harus menjaga perilaku kita bukan hanya di pengadilan, tetapi juga perilaku kita di luar pengadilan. Bahkan kadang-kadang kita disorot ketika sebagai hakim makan di warung Tegal, warteg. Kadang-kadang kita disorot sebagai hakim naik ojek. Kadang-kadang kita disorot ketika kita duduk dalam pertemuan di belakang. Jadi being judge here is not easy. Karena itu kita akan mendapatkan materi yang menurut saya sangat bagus, dan feel free to ask questions. Feel free to ask questions. Bisa bertanya dalam bahasa Indonesia, bisa juga bertanya dalam bahasa Inggris. Tapi yang dari agama jangan bertanya dalam bahasa Arab ya. Okay, so welcome to our training center. And before we start the speech, saya akan bacakan CV beliau. Yang pertama adalah Chief Justice Federal Court, Federal Circuit and Family Court, the Honorable Justice William Ostergrid. Welcome to Jakarta. Beliau diangkat sebagai Chief Justice Family Court Australia tanggal 10 Desember 2018. Bulannya sama dengan saya ketika saya disumpah sebagai Hakim Agung, Desember 2018. Diangkat sebagai Chief Judge Federal Circuit Court Australia in Oktober 2017. Beliau menyandang dua pengangkatan, yaitu sebagai Deputy Chief Justice of Family Court from December 2017 and has presided over the appeals divisions of Family Court since March 2018. Telah berpraktek sebagai barrister sejak tahun 1991. Jadi sebagai informasi, being judge di Australia Federal Court tidak seperti di Indonesia. from fresh graduate, and then you pass the test, and then you go to training for months here. And then you got another test if you pass, and then you be judge. Di Australia sebagian besar sudah praktek sebagai barrister, kemudian diangkat sebagai hakim. The Honorable Justice William Alston Green menyandang Bachelor of Art and Bachelor of Law LLB from the University of Melbourne and Master of Law. So welcome once again Justice William Alston Green. And then the second speaker is the Honorable Justice Bernard Collier, a judge Federal Court of Australia. During 2006 and 2011, appointed as court judge, a judge of Supreme and National Court of Papua New Guinea, and deputy president of the Administrative Appeal Tribunals, and an additional judge of Supreme Court of the Australian Territory. So just wondering, have you ever have chance to transfer to look around Papua Barat? Good, very good. Pernah ke Papua? Mungkin di sini juga belum pernah, ya. Mungkin ada yang belum pernah ke Papua. Belum pernah. They never been in Papua, and you were there. Yeah. Not West Papua. Okay. Justice Collier has written widely in relation to aspects of insolvency law, commercial law, and medical legal practice. Nanti teman-teman yang dari agama, silakan tanya tentang komersial, karena pengadilan agama punya kewenangan untuk memeriksa dan memutus perkara syariah, ekonomik syariah. Jadi siap-siap saja nanti bertanya kepada beliau. Dari segi pendidikan, Justice Bernard Collier got a Bachelor of Arts LLB from Queensland University and Master of Law from Melbourne University. All right. So without further ado, I think I'll ask Chief Justice to speak. And I think you may use like 20 minutes. It's okay. Then we can now follow with question and answer sessions for about 30 minutes, and can be extended. Let's see what happens then. Yeah. But I do expect teman-teman bertanya sebanyak mungkin. Feel free to ask questions. Bahasa Indonesia silakan, bahasa Inggris silakan. Please, Chief Justice.
Thank you very much, and I'm delighted to be here, and thank you all for being here and inviting us to this magnificent facility, and thank you for singing Waltzing Matilda. It was fantastic. One of the things you learn about being a judge is you're not always welcomed into a room. That was the best welcome I have ever had. It was wonderful, and in fact you know more of the words than most Australians, so well done. Can I also say congratulations to all of you for deciding to be a judge or wanting to be a judge. It is such an important part of our society, and it's so important that we have such dedicated people who are prepared to give their working lives to this profession. So congratulations to all of you. I also wanted to particularly acknowledge the military judges or the trainees cadets. I am in the Royal Australian Navy. I'm much older than you, but I am still on the military panel, and I'm very excited to see you all. You look magnificent in your uniforms, and you are such an important part of the military justice process. So I came to being a judge from being a lawyer for many years. I was an old barrister and thought I would finish my life as a barrister in chambers with one secretary and be doing cases in court. What I found was I was offered the opportunity in 2017 to lead a court called the Federal Circuit Court, as it was then. We had 65 judges in 17 locations around Australia and another 37 regional locations. And it was such an important job. I was so honoured to be asked, and I must say it took me a long time to get used to the fact that I was going to do it. In my case, I became the head of the court from firstly being asked on a Friday, and the following Tuesday the government announced my appointment. So it was a big shock. It was an even bigger shock for my family. But it is such an honour to do what we do, and it is such a great opportunity to serve the people. I think every day we have to remember, and I always remember, what an honour it is every day to go to work and help litigants get through some of the most difficult times in their lives. When we start being judges, we are in Australia asked to take an oath or an affirmation to decide cases without fear or favour, affection or ill will. And they're very, very important words. It's important because we must be independent. We must be fair. We must take on the responsibility of justice and access to justice for so many people. It is probably one of the most important parts of a democratic process or a modern society. And because of that, people must have faith, not only in what you do and what you're going to do, but also the court itself. So I thought I'd just explain to you what it was like for me, and it's different for everyone, but what it was like for me to become a judge. Because unlike you, I was a lot older and I'd been reasonably set in my ways, I loved being in court. I loved arguing cases, dealing with clients, arguing areas of law. Suddenly, I had to make those decisions myself rather than just argue them. It's a huge responsibility, and you really have to prepare yourself for that. It is also a huge adjustment because, as was said previously, with huge respect and a huge honour that you do get comes huge responsibility, and that affects your everyday life and that of your family. Firstly, you are no longer part of the profession. You are no longer just a normal person going to work every day. You must be independent and you must act in a respectful way, because if you don't, of course, you bring disrespect not only upon yourself but upon the institution you serve, and that diminishes people's confidence in that institution. So I found, firstly, in Australia, the title of being a judge hard to get used to. People used to, for the first few weeks, say Chief Justice, and I'd look around to see who they were talking to. But it was also going to court for the first time. And one of the things I found was interesting was I was always used to being an advocate on the other side of what we call the bar table. Coming to court, nervous, working very hard, then getting there and fighting the case, putting all the arguments needed to be put, getting the evidence we needed, and at the end, I could leave and celebrate that it was over and go on to the next case. as a judge and also as an advocate, I stood up in court most of the time. I did this for 25 years or 28 years. Suddenly, as a judge, I'm sitting obviously on a bench looking down on people. I've got to make sure I don't talk during the case too much rather than argue it as I used to. And secondly, I have to spend all my time sitting down, not standing up. It's a big difference. But it is also really important to understand that you're going from a system where you may be different, but for us, some of us were sole traders or single traders, some of us were in law firms, others were barristers at the bar. We only had a few people we were dealing with, we had close friends. You leave that environment and go into a totally different environment as a judge. Some of you may have to leave your hometowns or home cities to serve in other places. Some may have to leave their families behind. It's a great sacrifice and something you really have to get used to, but also make sure your family understand as supportive. You also have to get used to the fact that you become a judge, you get into a very large legal system. And one of the things that's so important is to remember you're only a small part of that legal system, but you are part of it. It's often said when people come to court and they bow to the judge, they're not bowing to you personally, they're bowing to the institution. And you're part of that institution. So it's very important to remember how important that is. But again, if every day you go in and you remember what an honour it is, it's much easier to adjust. It is also an adjustment because you are the decision maker. So you must obviously make sure you've got as much information as you can when you hear cases, but then have the confidence to make those decisions. People need you to make a decision to the best of your ability. It may be right or it may be wrong. That's what the appeal court's there for. People can appeal, they can decide if they would have done it differently. But that doesn't mean that your ability to make those decisions is diminished. Also, you'll find that it's a different type of work. You'll find yourself working very hard, probably the hardest you've ever worked. But you're doing it for the good of the people you serve. You may find you're working on the weekends or at night, not spending as much time with your family, because you've got to make sure you get through the cases and give people justice as quickly as they can. One of the most important things for any judge is to decide cases, but also decide them in what we call a timely way. That means there is no point hearing the case and then delaying too much before you actually hand down your decision. If you can do your decision there and then, and you've prepared, very good. If you need some time, that's important, but not too long. I think also, as a judge, what I had to learn, I had to listen. My job prior to that was to make sure that I could tell the judge what he or she should do. Now as a judge, I have to listen to the submissions made and make sure that I do listen. Some of it's nonsense, but I still have to listen to it. But it is very careful. You have to carefully listen and do your reasons. I think one of the things also for us was when we became judges, we had to not only make decisions, but we had to write reasons for our decisions. And that's a skill that's different from just being a lawyer, if I can say, and it's something you really have to seek help in. Some people, it doesn't come naturally, and it takes some time. But the great thing about our system of justice is there is always people prepared to help you gain those skills if you haven't had them when you first come to court. You're getting those magnificent skills in this great facility and the great training you're already getting. It is so important. And I think also as judges, remember you're human. Remember that you can always ask for help. You're not alone. Don't ever think you can't ask for help from your colleagues to make sure that you're able to do the work you're doing, because everybody wants you to succeed. The other thing I had to learn is that it's often much harder to write a short judgment than a long judgment. It takes a lot more work. It's easier to read for the person reading it, but it's harder for you because you have to condense all the material. And there is great responsibility. One of the things I found, and it surprised me, was, even though I was a very experienced lawyer, when you are hearing some of these cases, whether it's domestic violence, sexual assault, criminal cases, other complex cases where you're dealing with people who are under great stress or suffering, and they are very difficult subject matters, it takes a toll on you as a judge. We give our judges what we call trauma training to make sure that they are not overburdened by that. So it's important to recognise that there will be a toll on you when you're dealing with cases on. There's a lot of stress and there's a lot of pressure. So make sure that you talk to your colleagues about that and you deal with it. One of the ways I deal with it is to get away, do some exercise, talk to my family, talk to my colleagues. And I know that just relieves the pressure and I can get on with my work. I think the other thing is, and I wanted to mention this to you, in Australia, like many other countries around the world, we have particular rules about judges remaining independent. And I wanted to tell you a quick story about one case that is a reported case where a judge was very friendly with a lawyer during an actual hearing of a case. Unfortunately, they remained friendly during the actual trial that was being heard. And it was alleged the judge was very biased against the other litigant. It turned out that after the trial, it was discovered that the judge and the lawyer had been meeting on a regular basis right through the trial. It gave an apprehension of bias, if not an actual bias, involving the case. And the rules of our profession don't allow it, but more importantly for the judge, it was very important because what he did was diminish confidence in our system of justice and access to justice. And the litigant appealed because they believed there was an apprehension of bias. In other words, he wasn't independent. So despite denials about what had actually occurred, that case went to an appeal. I was sitting on the appeal as Chief Justice and I allowed the appeal on that basis. Then they appealed again to our highest court, the High Court, and they decided the same way as I did, that the whole case had to be reheard because the judge hadn't maintained his independence and the practitioner had actually ended up breaching her ethical obligations. That's just a quick indication of the fact that these rules are there for a purpose. And if you do not remain independent or give the perception of remaining and not being independent, it affects people's confidence. And also it costs people a lot of money. So I just wanted to give you that. But I wanted to, again, congratulate you, wish you well, wish my colleagues in the military part of the tribunal well, and thank you very much.
Thank you very much. Banyak isu penting di sini ya. Sebagai hakim, tentu sudah harus tampil tidak seperti normal person. Dan independensi menjadi taruhannya, integrity menjadi taruhannya untuk bisa mendapatkan kehormatan, respect by other people. Tentu kita harus menjaga integritas. Pressure tentu dihadapi, beliau juga menghadapi tentang pressure. Hampir sama dengan yang saya alami. dulu sebagai advokat, saya harus sosialisasi, saya harus publikasi kemampuan saya ke banyak orang, bagi-bagi business card, bagi-bagi artikel agar saya diketahui oleh calon klien. Begitu menjadi hakim, itu semua nggak boleh dilakukan. Agak aneh kalau ada hakim kemudian bagi-bagi business card kepada siapa saja. Kalau toh kita bagi business card tentu dengan sesama hakim. Like the one I did, I gave a business card to our colleague from Australia, but not for business player. Kami dididik sebagai hakim adalah silent profession. Kita harus make a distance dengan teman-teman yang lama. Itu yang saya miss. Sebagai advokat, dulu saya bergaul di organisasi profesi. Sejak jadi hakim, now I never make a connection directly to them. Kalau ada pertemuan juga ya singkat, kemudian mencegah untuk tidak involve terlalu dalam ya. Jadi memang hakim adalah profesi yang silent dan kita harus siap menjadi abnormal person ya. Okay, the second speaker is also very important. Justice Bernard Kulir akan bicara tentang emerging challenge for judge hearing in commercial cases. Ini tantangan bagi kita hakim ketika kita memeriksa perkara-perkara komersial. Ini juga berlaku untuk teman-teman pengadilan agama karena Anda akan memeriksa perkara ekonomi syariah, perbankan syariah, asuransi syariah, takaful. Ya. Jadi saya kira ini patut untuk dicatat. So the floor is yours, Justice. 15, 20 minutes is up to you, and then followed by question and answer sessions. Please.
Terima kasih. Selamat pagi rekan-rekan saya. Kami merasa terhormat berada di sini. Nama saya Bernard Collier. I will now turn to English. Now, the first thing I want to say is that Ibu Bang Bang said to me, "How long ago was that photograph of you taken?" And I think it may be because it's in black and white. Maybe he thinks it's very, very old. So just because I'm among friends, I also want to thank you for your very warm welcome. I'm delighted to see so many women here, like me. I'm delighted to see the military as well. Aku sudah menikah. Satu suami, satu anak perempuan, dua anak laki-laki, satu cucu perempuan. But one of my anak laki-laki is in the military in Australia. So for me, very happy to see you. Bapak. All right, now I am not going to lie. I have rewritten my paper about 3 times in the last week, trying to think of the best way to present to you what I see as emerging challenges of judges in hearing commercial cases. But what I thought I'd do is, when I'm talking about emerging challenges, to try to think of things that are not only new, but will present challenges for judges and things which you will understand better than I ever will, because you are young and you have been born into a time when IT and many other issues associated with IT are so important. You have grown up with them. So what I want to do in the 15 to 20 minutes available,
Just Bernard, just like a singer, make it closer to the mic.
closer, is
Yes.
better?
Ah,
Better? Okay.
yes.
I want to talk about 3 things. Better? The first thing I want to talk about is artificial intelligence. The second thing I want to talk about is cryptocurrency. And the third thing I want to talk about is environmental and climate change litigation. These are all things which are coming fast, and you will understand them. So my internet searches tells me that ChatGPT is alive and well here in Indonesia. I won't tell you what ChatGPT is. You know already. I have never used it. I'm too afraid to, because I think I might suddenly become addicted to using it. It becomes too easy. But AI is something we are all going to have to face. First, because it's becoming an important research tool for writing reasons. We will eventually use it, if not tomorrow. I was looking recently at a database called VLEX, which describes itself as bridging the gap between legal information and technology. When you use VLEX, you ask it a question and it gives you an answer. Something like, can I register a trademark in relation to carpets in Indonesia? And it will come up with an opinion as to whether or not you can do that. Now, perhaps more importantly, parties are beginning to use AI. In Australia, major law firms are asking whether AI can do the work of graduate lawyers. And self-represented litigants, those people who come to court without a lawyer, are using it. Now, on balance, the availability of AI to litigants can promote public trust and confidence in the judicial system because it makes justice more accessible. But as judges, we must be alive to the risks that come with AI. So the risk of AI is that it can possibly provide incorrect answers, but with great confidence. So it has been observed that AI can provide fictitious case law that closely resembles a judicial decision. It might also cite decisions that have been reversed on appeal, or provide information, say, about American law, which doesn't apply here. So we need to be wary. Also, AI can be used to prepare witness or expert statements and other evidence which might not truthfully represent the facts. The Supreme Court of Victoria in Australia has developed guidelines for litigants in using AI. It could be worth an examination. It's very new. One of the things that these guidelines do is tell parties to tell the court if they use AI. The use of AI may also have an impact on costs. So if you have a big law firm appearing in front of you and they've used AI to prepare a lot of their material, that should reflect in the costs. So that is a challenge for us all. Now, the second thing, as I said, that I'd like to talk about is cryptocurrency. Have you all played Pokemon? Yes? No? I'm quite familiar with it from my own children. I had a case a few years ago looking at Pokemon and NFTs. So my understanding is that the cryptocurrency market is a similar concept. It concerns computer code. The cryptocurrency markets have exploded. As of Monday this week, the global cryptocurrency market cap was, according to Forbes Business Magazine, $2.37 trillion US. Just to put that into perspective, that is double the entire gross domestic product of Indonesia. It's an insane amount. Disputes involving cryptocurrency have also increased. and they provide challenges for judges. The first challenge for judges in commercial disputes involving cryptocurrency, in my view, is actually trying to understand how it works. 2 weeks ago, my staff and I sat up till midnight, 2 nights in a row, trying to understand what was going on in a cryptocurrency case. There is an entire language which applies to cryptocurrency and unfamiliar concepts, at least unfamiliar to me. I have a list of them, but I won't go through them. But it is a challenge. A follow-up problem to that, of course, is that it's not only the judges who struggle. My observation has been that lawyers can struggle as well. In the case I had 2 weeks ago, I watched a lawyer who's about my age, I know him quite well, looking at me very earnestly and saying, "Your Honour, it's like having a Ferrari car parked outside the court. And several people have keys to the car. And you can't get the keys off them because it's computer code." And I thought, do you really understand this? My view is we will all require education to understand it. But that is why I said you are better equipped than I am to deal with it. Of course, the second problem with the cryptocurrency markets is that they are borderless. The case I had, and which I still have, involves people all around Asia. The Australian regulator is not happy, but they have to deal with it too. So we have more cases coming out in Australia. There may be, I imagine there are cases coming here in Indonesia. And we will have to learn about it. The third challenge I want to quickly go through is increased litigation in the area of climate change and the environment. What types of claims will the courts entertain? What type of evidence will we accept? What plaintiffs are able to bring cases? What defendants will be liable? According to a recent report published by Columbia University, the number of cases involving litigation to compel countries and companies to reduce their carbon emissions has more than doubled in the last 5 years. We've had our share of these cases in Australia. One example I will just pick out involved a decision of the full court of the federal court where the judges held that the court would not impose a duty on the federal Minister for the Environment to take into account causing personal injury or death to all people under the age of 18, which is what the case was about. Because what was happening was that there was a coal mine which was being developed and an environmental group brought litigation. Cases like this require detailed expert evidence and consideration of that evidence. I myself have an environmental case at the moment. It's causing me to think about it a lot at night. It involves litigation between a mining company which wants to dispose of carbon dioxide waste into massive underground lakes in Australia. On the other side is farming groups. When I called for the first case management for this matter, hundreds of people turned up, flying into Brisbane. Cases like this require you as judges to consider how you are going to manage expectations and the emotions of people which will run high. In conclusion, I just want to say that in cases like all the ones I've described, careful case management, mediation, and expert evidence are critical. Ongoing education of the judiciary to properly deal with such cases is vital. You are the future of the judiciary. You will bring your skills to these matters. Terima kasih.
Excellent. Thank you. Topiknya sangat modern dan kekinian, ya. Artificial intelligence. Ini pasti akan banyak pertanyaan. Yang kedua tentang pembuktian untuk kripto. Sebagai just sharing the current situation of our crypto. We have about 500 more registered crypto product, and the growth is very, a jump growth. In 2023, the transaction is about 149 trillion rupiah. And it's jumped from 2020, it's about more than 100%. And the predictions for this year of the crypto transaction is about 800 trillion rupiah here. It's about 18,000 investors registered right now here in the crypto market. Jadi ini transaksi yang sekarang terjadi, sehingga kita sebagai hakim memang ya harus paham produk kripto ini. Ini tugas dari Pak Kepala Badan, Pak Pusdiklat ini. Materi bagi hakim yang akan datang ya transaksi modern seperti ini. So far there is no case right now up till now ya in a judiciary as far as I know about the crypto product. Tapi sebagai hakim, karena hukum kita mengatakan kita tidak boleh menolak mengadili perkara apapun. Meskipun hukumnya belum ada, act-nya belum ada, statutnya belum ada. Tapi kalau perkara itu diajukan kepada pengadilan, hakim tidak boleh menolak memeriksa. Sementara ini ada transaksi produk baru namanya kripto. Well, I leave this and now we go to question and answer sessions. Very good. Kita punya waktu, Pak Bambang, sampai jam berapa kita? 30 minutes. Look at the questions, you know. It's like 30 questions there. Bisa lebih lah, Yeah? Okay. I suggest that we have 45 minutes, yeah? 45 minutes. And after that, we have another agenda. Okay. Wow. That's very good. I take 5 questions first. Yeah, for the. I take 2 questions from this side and 3 questions from that side. I don't know which one go first, but I take that one. You, 1, 2, yeah, in the front. 3, there's 2 gentlemen and lady, and the one. Okay. You go first. Here. Okay, mention your name. Singkat tapi jelas ya. Singkat tapi jelas karena banyak. Jadi langsung saja pertanyaannya ya.
Thank you, Justice, for the very respectful and interesting speech. My name is Laila. I'm from Class B. And my question to Justice Alsterkin, since you mentioned about the challenge of becoming a judge in Australia, there are a lot of issues and problems regarding the contempt of court in Indonesia. And I have ever read about the contempt of court regulation in Australia that is stated in local act in 27, if I'm not mistaken, that you protect judges from the contempt of court. So how is the implementation and how does the government of Australia protect the judges, especially the women judges, that we are so vulnerable from being maybe harassed or contempt of court, that a lot happen in Indonesia these days. So how does the government of Australia protect, especially for women judges? And for Justice Collier, I want to ask.
Just take one question, okay?
Oh, okay.
There are 2 lots, okay. Very good. second, no, here, yes, lady in the front. Please make one question, okay?
Okay, thank you. It's an honor to get the opportunity to ask the question. Let me introduce myself. My name is Intan Indrawati. I am the president of the candidate of judge. Thank you. Thank you, sir. Here are my questions. In Indonesia, we have a concern that a judge get a lower salary than the lawyers. But as you said, as a judge, we are the most important profession of the law. So, how much salary of judge in Federal Court of Australia, chief judge in Australia, and salary of judge in local court Australia? Thank you, sir.
Not enough. But
Okay,
okay.
Okay. There must be very interesting answer. Don't worry about that. Okay, third.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, Your Honor, Supreme Court Judge of Indonesia, Mr. Samsul Mari, SHLLM PhD. Your Honor, Bernard Collier, Justice of Federal Court of Australia. Your Honor, William Sturgeon, Chief Justice of Federal Circuit and Family Court of Australia. Good morning, ladies and gentlemen, judges candidate of Indonesia 2024-2025. It's a great chance for me to ask you a question. Stand up in here. And
Your
to be
name
honest,
is? Your name?
Anissa from G class. To be honest, I have 3 questions, but since I have to ask one question, so I choose.
Please, just one question.
Okay. Yes, sir. If there is a mixed marriage, because in here the family violence and family law cases, so I asked about family law in Australia. If there is a mixed marriage, for example, between Australian citizens and foreigner, like maybe Indonesian citizen, how is Australian law application in marital property when the husband or the wife get divorced? Can the foreign citizen wife or husband get the property like houses or lands or anything that they get in their marriage, especially if the property is located in Australia or in foreign country? Thank
Very
you.
good. Do you have a boyfriend in Australia? Okay, thank you. The fourth question, please. Yes.
Thank you for the opportunity. It's an honor. Thank you and welcome to Indonesia. I am a kid from the heart of Borneo.
Sorry,
Central
your
Kalimantan.
name?
My name is Kevin.
Kevin.
Yes, I am from G class. And my question is very simple. 2020, I wrote about intellectual property, especially trademark, and I compare my papers to Singapore and India, but I don't learn about Australian legal system yet. So please tell me and tell everybody here how the Australian legal system solve the intellectual property in terms of good faith principles. That's
Okay.
all. God bless. Thank you.
Okay, no, it's very short question, but the answer will be at 1 semester. Anyway, okay, the final questions. Yes, you guys. No, that one. The one studying, yeah. Okay, straight to the questions.
Yeah. Okay, sir. I will straight to the question. My name is Yusuf Sawardana, and I directed this question to the Honorable Bernard Collier. And my question is, will blockchain technology be used as evidence in Australia, just like in United States? I wanted to know your opinion. Thank you, Mrs.
Okay, thank you very much. It's a very good questions, and well, I want the Chief Justice and Justice Berno also make a response. First, Chief.
Okay, so was it Layla who was over there? Yes, thank you.
Laila, yes.
Okay, Layla. Firstly, in relation to contempt, and particularly for women. So we have a majority, in our courts, we have a majority of women. So of all our judges, 58% are women.
58%.
And Judge Boyle's here, she's one of our leaders. And knowing Judge Boyle in court, you never have to worry about contempt. We have very strict rules, and people must act in a respectful way, and we have zero tolerance for in court for people misbehaving in front of judges, whether they're female or male. We have court security, and we take this very seriously. Also, that goes for judges whether they're in the court or outside the court. Also, the profession must be respectful, and their colleagues must be respectful. So we have, the Australian government has legislation in place, but judges very much enforce that legislation. There is particular requirements for the process of contempt of court, and it's a very serious matter. And there are certain processes that must be followed. What normally happens is if someone's found in contempt of court by a judge, normally there is a process where what we call the marshal, I love having a marshal, we have a marshal or the registrar will actually be the prosecutor and will bring that action to a different judge for contempt, or the same judge, normally a different judge, and there is a prosecution process. But there is a lot of protection for women judges. We had a situation last year where we had, because we had a lack of indemnity for judges for a while, and interestingly, the female judges were the ones who were threatened by litigants to sue them for damages if they got the case wrong. Once legislation was back in place, we have no problem. But it is a live issue, and we take it very seriously.
Thank you. Justice, yes.
Thank you for your question about protection. I think it's important, particularly as a woman judge. I will often go for a walk at night around my neighbourhood with my dogs, and sometimes I think, am I going to walk around and find some unhappy litigant waiting for me? It's never happened, but you do think. One other thing is our court provides security at home for judges. That could be something you might want to investigate when you become a judge. I have an alarm system, personal duress systems, and so on. And the court pays for that, which is very good. So I just think that that is something you might want to just consider. I guess the other thing is just really supporting what Chief Justice Ulstergren has just said. I think it's very important in court I always try to have what my son calls my game face on. So I'm only there to hear the case. I don't get emotional. I won't put up with people being rude to each other in court. I just won't tolerate it. It's zero tolerance, like His Honour has said. And just try to stay away. But I will say this. I grew my hair because one time I was walking outside of the court a few years ago, long time ago, walking back with a coffee in my hands. And I was walking back to court, it was lunchtime. And as I was coming down the street, I saw somebody coming towards me, and I thought, I know that person, who is it? And so, when you see someone you do, you just react. So I just sort of was like, he saw me do this, and he came over and he said, I know you, but you're Justice Collier, you destroyed my life. And I said, sorry you feel that way. Well, what else was I supposed to say? And he said, I'm going to appeal though, And I said, that's why we have a democracy and a court system. And off I went. Since that day, I grew my hair when I'm in court and feel threatened. I put my hair up. If it's a particularly creepy party, I'll put my glasses on, even though I may not need them. And when I leave, I'll put my sunglasses on and let my hair out. And I look unrecognisable, at least I think I do. But it's a thing. Being a judge, I don't want to paint a picture of living in terror. It's not the case at all. But I also just want parties to leave me alone when I leave the court. I don't want to talk to them if I see them in the street. So, and this gets back to what Chief Justice Alstreghan said in the first place. When you become a judge, your life changes. In many ways for the better, in most ways, but a few not so good.
Thank you very much. Second question is for the salary, but please be prepared. Don't be jealous, okay? Salary of the judge.
What was the salary?
Yes.
Yeah, we definitely don't get paid enough. And often people, that's part of the sacrifice of becoming a judge and serving the people. So there are great benefits and great responsibilities and a great honour, but also there is a sacrifice. And one of those sacrifices is that we are serving the people and we are public, effectively not public servants, but we are part of the public staff that do that. So unfortunately we never get paid enough, but more importantly, a lot of the services that provide help for litigants like legal aid, they're never paid enough. Most people in the legal system never get paid enough, unfortunately. Maybe we could have a profit sharing situation on the case, I'm not sure.
Chief, compared to your income as barrister,
you make me feel very sad now. A lot of judges, when they're barristers and they're senior, they enjoy they've got very senior and they enjoy a very good salary. And when they become a judge, there's a lot less money, but it's still, as you say, a great honour. And that's the way I have to deal with it.
well, here actually, in terms of the performance, performance of judge compared to the advocate or practicing lawyer is uncomparable. The judge usually have sometime, go to office, check the object, the online bicycle, etc. While the practicing lawyer come with a luxury car, BMW, etc. So I don't know. Our institute still do the best to increase the salary, but still in negotiation. But the interesting point that made by Justice Kohler is that their home secure. I mean, you have the security guarantee at your home, while here there's no such facilities here.
I think that's something that might be investigated, something that perhaps the judiciary could consider taking on. I was actually talking to one of my colleagues in Sydney the other day about this exact thing, because we had a litigant in person who was causing some concerns for one of our colleagues, and I said to him, talk with Ms. Sia Lagos about getting security at your house if you are genuinely concerned, because he didn't have it. We also have, another thing is, our names and addresses are suppressed in things like electoral rolls.
Right.
land titles, government documents, silent phone numbers back in the day when everybody had landlines. And even now, still are some landlines, but we have a suppressed number. We take security seriously. We had in Chief Justice Olstergan's court, I still remember it, I was a teenager when Justice David Opas was shot dead at his house. Family law plainly gets people's emotions riled. And Mrs. Pearl Watson, I remember that too well. The horror of that. People just doing their jobs.
Yeah, okay.
Yeah, I was going to say, so we had one case in particular, unfortunately, where a litigant was an engineer, and he not only shot one judge, he's now been found many years later guilty, but also he bombed another judge's house, he bombed the court, and he also threatened other people. He allegedly also broke in. The church helped a wife get away because he was an abusive husband. He broke into the church one night and put bombs in it. And he was only convicted many years later of killing all these people because he cut his hand on the window as he got in, and the DNA evidence that was developed later on gave the proof that it was actually him, but it took many years. And during that time, one of the people involved in the case was a man called Gary Watts. And Gary Watts was a solicitor or a lawyer acting on behalf of the wife. Yeah. He had been threatened. He left the case and moved away into the country out of Sydney. He sold his house very quietly. A week after he sold his house, the man who bought the house found a large bomb in his car. And it was only because the dog was barking that he looked inside the car. And if that bomb had gone off, it would have blown up half the neighbourhood. So there are real threats, and that was an act of urban terrorism, but it was against a judge. Now, we would never have thought that was possible, but unfortunately it is. People can, and this man who did it had no convictions prior to this. There was no indication that he was the sort of person that would do these sort of things. So unfortunately, when you hear cases, there is real danger, and people get very stressed, and unfortunately you can bring out the worst in them. So safety is a real issue.
Okay.
Can I just add one last thing? I'm sorry, Pa.
Sure.
Just one last thing. Remember, a case may be nothing to you really, other than doing your job. You have no emotional engagement. But the people there, it's different for them. For them, it could be the most important thing that's happened to them in years. So just remember that. Because I think I always try to remind myself of that. And I just try to be almost invisible on the bench as a judge, not as a person. I don't want people to look at me as a person when I'm in court.
Thank you. The other question is actually about the mixed marriage. Yeah. So
I have a mixed marriage. My husband is from Melbourne and I'm from Brisbane. You may laugh, but when we talk about sport, it's a big deal.
yeah.
Justice Collier's from Queensland. They're a bit strange up there. Now, the idea, I think the question about a mixed marriage, in Australia, what we do is we decide what is the proper forum to bring an action or to be able to hear an action. Normally, there's a number of criteria. One of them is whether the people are citizens of Australia, or one of them is whether they live there, what property they have there, and depending upon the answers to that, often we have to decide is it appropriate to have the case heard, the divorce or the case heard themselves in Australia or in say Indonesia. And it will depend a lot upon the criteria. If the property's in Australia, if they were married in Australia, and for instance, if one of them or both of them were Australian citizens, or has a residency there, often we will hear the case and determine it, and that judgment then has to be enforced in Indonesia if some of the property is in Indonesia. But normally, if the property is in Australia, we'll hear the case in Australia.
Okay, so don't worry if you are not married to Australian, you still have some right, yeah? Okay, I'm sorry, we have only 15 minutes left. And, but I'm gonna take 5 questions, yeah? I take 3 from the back. Okay, and then, no, 2 here. And then 3 of my left. Okay, I take 3 from back, please. Yes, I don't know, you just talk to your friend, you know, which one go first. The back. Yes, 1, 2, yes, 3. Okay, you first.
Park, can I also just say, just interrupting quickly,
Sure.
the judge candidate who asked me about blockchain, see me afterwards. See me afterwards.
Yeah.
I'll talk to you about it then.
Okay, very good. Please, first questions. The mic, yes. Were you in line here? 1, 2, 3, 4, 5. Okay. Okay, stop right there. Okay, 2 from here. Okay, please the mic, yes. Okay, make sure 1 questions.
Thank you, Your Honor.
Okay, thank
Assalamualaikum warahmatullahi wabarakatuh.
Salam.
Let me introduce myself. My name is Muhammad Akwam Tariq from B class religion, sir. Thank you, Your Honor. Maybe I would like ask 1 question, especially to the Honorable Mr. William Estergen.
Jesse Berner Corporation.
Yes. In the case of divorce, for example, in the family law in Australia, if in the family violence occurring alongside to the divorce proceeding, which one will be processed first, the civil case or the criminal case, sir? Maybe in Australia. Yes. Thank you.
Okay. Second question.
Okay, thank you for the opportunity. It's an honor to me for stand here. Okay, in Australia,
Your name is?
My name is Ahmad Riza Bibi from
Ahmad Riza.
Abicles religion. Okay, in Australia, domestic and family violence is a major health and human rights issues. Technology is increasingly being recognized as an important tool to assist victims or survivors of DFV in accessing legal services. My question is, how do Australian courts deal with the issue posed by improvement in information technology when resolving the domestic and family violence cases? And are there procedural statutes that govern case examination in proving domestic and family violence cases using electronic evidence? Thank you.
Okay, thank you. Talking about the evidence. Seth?
Thank you very much for the opportunity. I would like to address the question for both.
Your name?
Yeah, my name is Mirza Falevi. If before we have a president of judge candidate, I myself the vice president of judge candidate. Okay, despite all of the temptations, I'm very sure that there are many challenges. So how do you keep your consistency and integrity by being a judge? Maybe I'm very sure that there are many people try to bribe you, but you keep your integrity you keep your consistency to produce high quality judgment. So what is the recipe? Thank you very much.
Thank you very much. Okay, the fourth question.
Good morning. Allow me to introduce myself. My name is Stephen, and I'm delighted.
Sorry?
and honored- Stephen, sir.
Stephen. Okay.
Yes, I'm delighted and honored to ask this question directly to you. My question based on domestic violence, ma'am and sir. Professor Richard Chisholm from Australian National University said that the most intimidating process of violence in domestic violence or family cases is to provide a proof that there is traumatic events that has happened. It also said in the Victorian law enforcement that it is the most stressful and intimidating part of the providing that there is a traumatic event has happened. So my question is, if someone has been a victim of traumatic events, that will make them a vulnerable person, such as stressful and anxious, how a judge examine or reviewing this kind of testimony or testimonial evidence from the person that has been traumatized in events? Thank you very much.
Thank you. Last question.
Thank you for the opportunity. My name is Sultan Rizky Muhammad from C General Class. I would like to address a question to Justice Alstergen. You have mentioned before about the trauma training for the judges. So I think, can you please elaborate it for us? I think it is very important as the mental health awareness is increased nowadays, and also there's a possibility for a lot of judge in the future that maybe meet with the cases with inhuman cruelty cases. Like, I think it is my question. Thank you.
Okay, thank you very much. So it seems to me it's all related to domestic violence, eh? And but there is one thing that's quite different, but the keeping the integrity and consistency being judged.
Can I just,
please?
Because this is mostly for Chief Justice Alstergen. Can I just say, I have never been approached with a bribe, never. The first thing I would do would be to contact the Chief Justice and the court, and criminal action would be taken if that was the case.
Mm-hmm.
Remember, all you have is your integrity. You must defend it. It's so important, not just to you personally, but to the judicial system. Maintaining public confidence in the courts holds the country together in so many ways. It's such an awesome responsibility. I've seen this in Papua New Guinea, where I'm a judge, where at one point they were saying it was the Supreme Court of Papua New Guinea that was holding the country together in the constitutional crises of the 2010s. You must have integrity. Thank you.
Thank you very much. So, Chief, you are now respond the...
Okay, well, can I say, firstly, I agree with Justice Collier. I think we're very lucky in Australia that I've never seen any bribes or any suggestion of bribes to judges. But obviously, as Justice Collier says, you can never compromise your integrity, because as soon as you do, you'll always have difficulty, you'll always be vulnerable. And so the easiest thing to do is just never ever do it and never put up with any of that kind of behaviour at all. In relation to the domestic violence issues, they're wonderful questions. I think if I can go through them very quickly, if there's a criminal proceeding, normally that will take precedence again before a family law proceeding or before a domestic violence proceeding, if the subject matter is the same. Often we have litigants, we have people that are a father often who's in jail as a result of a particular act of domestic violence, and we have to wait, or has been charged, and often we have to wait for the case to see if we can actually then deal with the civil case, if I can put it that way. Not always. If it's possible to deal with interim orders in the meantime, what should happen to the children, and if there can be an interim property settlement, we will do it. But if it's a matter of having a full hearing and credit findings, often, unfortunately, we do have to wait. Not always, but we do often have to wait as a result. We have two systems of justice. We have we have the Commonwealth system, and we have states and territories. Most of the crime is brought in the state courts, and the Commonwealth courts deal with family violence or family areas in most cases. I think the question about trauma training was an excellent one. Most people here would not expect to be affected by hearing cases. You would think that you can bring a professional mind to it, an objective mind, and it doesn't affect you. The problem with trauma and the problem with the kind of cases you will hear in your careers, your long careers, sometimes they will creep up on you. You will not recognise necessarily that you are traumatised about those cases. And often you need to talk to other people to have that recognised. You may find yourself in court sometimes overreacting to something because you've been traumatised by a different case, or being hardened by evidence when you should have taken it more into account because you've had to deal with very, very difficult issues. You are human, and you will be subjected to pressure and to trauma from these cases, even if you don't think you are. We make sure that we have regular training for all judges, particularly new judges, in relation to trauma, because we need them to be able to bring an objective mind, to stay healthy and stay able to hear these kind of cases. I've had some very, very experienced judges very badly affected by cases they never thought they were. We might have a situation where we're hearing a case and one of the parents kills the child as a result of the orders we make. We have to notify the judge, notify the staff, notify the social worker, and we have to make sure that we support them. But it doesn't have to be that extreme. We still make sure when people are on a monthly basis dealing with these sort of cases, we check in with them, and we have services available for counselling on a very confidential basis, as well as general training, which is very, very important. I think, what was the other thing?
Thank you.
Is there anything else about domestic?
The other question is about the, if happens about the domestic violence, and then go first to the criminal action.
That's right, we'll go
or-
with criminal, that's right, okay.
Can I just add something? And so I don't deal with family cases. That is the remit of His Honour's Court. But we have other cases in the federal court, migration cases which worry people a great deal. And it's also the pressure of the work can also get to people. The courts in recent years, His Honour's Court's been doing this for a long time, and our court more recently, just watching the judicial well-being or the well-being of the judges, and just making sure everybody at least is travelling together in as comfortable and content a way as they can as judges, because it's stressful sometimes. Sometimes I think to myself that my judgments which I need to get out are a bit like rats with very red eyes sitting in the corner staring at me, and I've got to deal with them sooner or later. They just never go away until you deal with them. So it can be stressful. It's also very rewarding. It's a hard job, but it's a very worthwhile job.
Thank you very much. Well, with that, we have to end this wonderful and informative and inspiring topics. Satu yang tidak bisa dinegosiasi adalah persoalan integrity. Integrity for justice is number one. When you receive a bribe, you will be known as corrupted justice forever. Forever. begitu Anda pernah nerima suap sekali saja, Anda akan terkenal di luar sebagai hakim yang bisa disogok. So please, ya, sejak awal itu harus dijauhi. Not tolerated, not negotiable. You have to maintain your integrity. Sekali saja kita pernah nerima, maka semua akan tahu. Lawyer akan tanya pertama kali siapa di antara hakim di pengadilan negeri yang bisa didekati. Itu pertama pertanyaan. Sekali Anda pernah dan bisa didekati, mereka akan tahu. Sulit bagi kita untuk membalik impresi setelah kita terima bribe. So please keep that in mind. Integrity is number one. With that, thank you very much. You want to add something?
I just want to add
Please.
one thing else. This has been not only the best welcome we've ever had with Waltzing Matilda, but also it is by far the most enthusiastic crowd of judges I've ever spoken to. Thank you very much.
Thank you very much. So with that, I return to your the MC. Thank you. Give a big applause to our speaker.
You can say to them, salam cadas. Salam cadas. Salam cadas. Cadas. Salam cadas. Yeah, yeah. Let's explain what cadas means. Cadas means cerdas, berintegritas means smart and intelligent. Salam cadas.
Salam Sadas.
Again.
Salam Sadas. One more time. Salam Sadas.
Terima kasih kami ucapkan kepada seluruh narasumber dan moderator atas perkenannya menyampaikan materi dalam kuliah umum ini. Semoga dapat memberikan manfaat bagi seluruh peserta dan seluruh undangan yang hadir. Kuliah umum selesai. Kami persilakan untuk seluruh delegasi menuju lokasi pemotretan yang diikuti oleh para peserta. Wassalamualaikum warahmatullahi wabarakatuh.
Satu. C. Tiapan untuk tim yang sudah dibagi berdasarkan gladi, tim pemotretan. Nanti langsung sebelah kantor atau sebelah auditorium.
Ya, perhatian untuk seluruh siswa. Untuk sesi pertama kelas umum ABC persiapan. Nanti setelah itu D, E, F, G, kemudian disusul dengan agama ABC dan kelas tun AB. Untuk kelas ABC